Hello, and welcome to this short webinar on ASI's antitrust compliance policy and what you need to know. I'm Fiona Solomon, the CEO of ASI, and this webinar is for those of you who are wanting to know a little bit more about this issue, or in fact might be considering nominating for a governance position in ASI, like on the board or on the standards committee. So, why is competition law important? Well, competition law, which is also known as antitrust law, is an important issue for initiatives like ASI that bring together competitors in the marketplace. There are plenty of recent examples and current examples of various serious investigations by regulators in a number of countries. ASI too is subject to this legislation, and it's our responsibility to make sure our participants understand how the law applies to us as an organisation and to them individually. So what is antitrust or competition law? The purpose of this law is really to ensure that markets are free and fair. The law usually sets out a number of requirements that aim to prohibit any distortions of competition. And the precise scope of the law depends and varies on the relevant country or jurisdiction. In general, competition laws strictly prohibit cartels where competing enterprises come together and collude on matters that are commercially sensitive. So typically hardcore restrictions between enterprises that competition laws prohibit include things like fixing prices, limiting production, or agreeing to share out markets by customers or territory, and in effect agreeing not to compete on those. And these kinds of restrictions are prohibited everywhere, irrespective of their actual effect upon the market. It's the activities themselves that are prohibited. So why does competition law matter to a sustainability initiative like ASI? Well, many ASI members commercially are subject to competition law themselves due to their commercial activities. So as an organisation, if you're in the value chain or in the supply chain, you need to be taking precautions when meeting competing enterprises in organisations like trade associations or standardisation bodies like ASI. Competition law also applies to ASI itself. So it applies to associations of enterprises like trade associations or like industry standardisation bodies, even when the decisions or the work of the association or initiative relates to responsible business conduct or encouraging sustainability. So ASI's own certification and standardisation activities are also subject to competition law. So the directors of our board at ASI have a really important responsibility in this area to oversee that. And compliance with the law is very important as competition rules are strictly enforced worldwide. Competition authorities have very wide-ranging powers of investigation, and they can seize any documents that are relevant to what they're investigating. The consequences of breaches, of course, are in fact very serious. A breach can result in severe consequences for the enterprises or persons concerned, and they can include things like significant fines. Some case examples have resulted in 10% of worldwide group annual turnover in some EU cases. It can result in custodial sentences, notably in the US, but also in some EU countries. It can result in agreements that have been deemed illegal, being declared void and unenforceable. It can result in individual directors being disqualified from holding a director position in future. And it can also result in damages being awarded by the courts. In particular, we see that in the US and the EU to any of those that have actually been harmed by the illegal conduct. So ASI, of course, seeks to manage this issue very carefully, and we have an antitrust compliance policy, which was first published in 2015, and it's been updated in 2017. It expressly sets out ASI's commitment to strictly comply with all competition and antitrust laws. And we believe that a robust competition policy is really essential to our success. There's no room for complacency on these issues because of the risks associated with them. It's not meant to discourage membership or participation in ASI, and it's really designed to ensure that members are in fact comfortable attending meetings and sharing legitimate information when involved in ASI initiatives, with the knowledge that we have a good understanding of what the limits are and what's acceptable behaviour. So as a result, it's relevant to every person that's involved in the activities of ASI, including employees from ASI like myself, and employees of members perhaps like yourself. It is the obligation of everyone, irrespective of whether you're working for a company or a civil society organisation or an association member, to be familiar with this policy and to abide by it at all times. The policy also sets out some golden rules, and we'll go through these on the next few slides. Firstly, members should always make their own unilateral educated decisions. That could be on the basis of information that we provide or on the basis of information from elsewhere. But ASI is not requiring decisions or requiring actions as a collective. Secondly, it's strictly prohibited to discuss any of the following commercially sensitive matters at any ASI meetings or events. That relates to previous, current or future prices, capacity and production information or forecasts, previous, current or future sales information, purchasing prices or trading terms with suppliers, previous, current or trading negotiations with individual customers, including bidding strategies for public or private contracts. This is, of course, where that information is commercially confidential or sensitive, where such information is already in the public domain and generally available. Of course, that's fine. Thirdly, it's strictly prohibited to discuss individual costs of compliance with ASI standards, and that could be things like labour costs, raw materials, environmental compliance costs, and so on. And again, that's where that information is commercially confidential because it relates into the costs of production and the pricing prohibitions that we discussed on the previous slide. It's also prohibited to discuss passing on the cost of compliance with ASI standards to customers, for example, through a premium for a certified products. Again, information might be collected through the marketplace that's publicly disclosed, but it's imperative that ASI avoid members coming together with the appearance of agreeing or discussing these kinds of costs or passing on costs. So as an example, in the EU, significant fines were imposed in the order of nearly €3 billion on truck manufacturers for, amongst other things, agreeing to pass on to customers the costs of new emissions technologies. And number 5 is that it's strictly prohibited to discuss any boycott or limitation on the purchase of raw materials, semi-finished products, equipment, services or other supplies from any supplier that doesn't meet ASI standards. So to support and make sure these golden rules are in place, some of the things that ASI as an organisation does is that we always have a written agenda for all of our meetings and events, and that includes the antitrust notice, which the Secretariat or the Chair always draws attention to. We strive to make sure that we have accurate and comprehensive minutes of these meetings. The Secretariat, a representative must always be present in them, and that person or people have the right to react to any inappropriate discussions. They can intervene to provide guidance on how to redirect that discussion. They can move to end any potentially illegal discussions, postpone further discussion until we've had some external legal advice on the matter. In some circumstances, it may be the action might be to end the meeting, and whatever the action is, we would record that in the minutes of the meeting. So moving now to statistics, which we talked a little bit about before. So competition laws do acknowledge, of course, that the collection and distribution of certain kinds of statistical data by trade associations and others is actually a legitimate activity. It's useful to the market as long as there are strict safeguards in place. So the kinds of safeguards that ASI has in place is that, as we talked about before, it's prohibited for ASI members to exchange commercially confidential information, and current data that is relevant for ASI's statistics is only disclosed in aggregated form so that individual market participants are not identifiable. The aggregation process itself can either be prepared by an independent external person or party, or by the ASI Secretariat in accordance with our confidentiality and IT policies. Exchange of historical data, or of course any publicly available data, isn't usually problematic, but in some circumstances we might need to seek antitrust legal advice. And no other kinds of information exchange is allowed within ASI in the absence of legal advice on those areas that have been flagged up as problematic. So thinking generally about standards and certification programs and what their roles are, Standards like ASI aim to define technical or quality requirements with which either products or production processes or services or other kinds of methods may comply. So in general, competition authorities, which manage competition law, recognise that standardisation agreements, like ASI's performance standard, for example, can produce significant positive effects for consumers by serving to maybe lower costs, ensure compatibility across practices, and promote economic interpenetration. However, where standardisation agreements can give rise to competition concerns can be where there's a restriction in price competition, there's any foreclosure of innovative technologies, or they serve to exclude or discriminate against certain companies by preventing them from having effective access to the standard. So here's what we do at ASI to address those. We adhere to best practices, including from codes of good practice set out by the ICL Alliance, and we have these kinds of factors in play in terms of our processes and procedures. We make sure that participation in standard setting is unrestricted. We make sure that audits of companies against the standard are undertaken by an independent organisation, independent to ASI and independent to the company being audited. We make sure that there's due process in determining the standard and a transparent procedure for adopting the standard. The standards aren't intended to limit any company's freedom or discretion to make their own business decisions or to prevent the manufacture or sale of any product not conforming to the standard or to have any effect of restraining competition. We're also pretty clear that there isn't an obligation to comply with the standard. ASI membership is voluntary, and so you sign up to ASI as a voluntary commitment to comply with or apply the performance standard to at least some part of your business, but that decision is a voluntary decision. We make sure that access to ASI standards are on fair, reasonable and non-discriminatory terms. They're publicly available on our website, and we're working to make them publicly available in a range of languages as well. And finally, ASI standards are regularly reviewed, at least every 5 years or more frequently as required. And then a final note, we've talked a fair bit about the law, about formal meetings of ASI, but it's also important to be aware that social and side meetings attended by competitors, perhaps in the name of ASI or associated with ASI, can also present a risk under competition law. So for antitrust enforcement agencies, it's not relevant whether an illegal agreement was reached at an informal setting or an informal setting. It just matters whether it's happened. So it's really important that ASI members and staff respect competition law and avoid commercially sensitive subjects during social gatherings, just like at formal meetings. We actually presented a antitrust vet training video, which is quite fun for some practical tips. It's only a few minutes long. You can see the link on the screen there if you'd like to have a look at that and learn a bit more about that context as well. So I want to thank you for your attention. I hope you learned a little bit more about both competition law in general and ASI's approach to this. And I thank you for your interest in ASI and its governance. Have a great day.